The Digital Personal Data Protection Bill may negatively impact how we, the public, can get information from the government. A provision in the bill could hit the 2005 Right to Information Act or RTI by removing the existing legal basis that permits government bodies to disclose personal information of some people in public interest. The draft of the Digital Personal Data Protection Bill that is in Parliament includes a designated section that significantly restricts Section 81J of the 2005 legislation. What exactly does Section 81J entails in the Right to Information Act, and how could this new amendment as proposed by DPDP bill impact the effectiveness of the RTI Act? We will tell you all of this and more. According to the existing provision, the RTI Act prevents the disclosure of personal information that is unrelated to any public activity or interest or causing unjustified intrusion into an individual's privacy unless there is a significant public interest warranting such revelations. On the other hand, the data bill seeks to do away with these conditions, imposing an across-the-board restriction on government agencies and prohibiting the divulgence of any private information regardless of the potential public interest involved. Activists argue that this will prevent government entities from revealing specific details including names of individuals which are currently accessible under Section 81J of the RTI Act.
The government is saying that anyone who collects any personal data will be made a data fiduciary, and they will have to fulfill many obligations under the law. Like, for example, if there is a small group that's doing a survey, or there are campaigns that work with the poor in villages or in slums to just make lists to find out who is getting their rations, who is getting their Narega wages, and so on. All of these will become data fiduciaries. Political parties will become data fiduciaries. Everyone will be covered under the ambit of this law, but the catch is that the central government has empowered itself to decide who will not be a data fiduciary and will be kept out of the ambit of the data protection law, which would mean that complaints can be raised against data fiduciaries.
Currently, in order to withhold personal information, it is required to substantiate the legitimacy of one or more of the following reasons. The information sought holds no pertinence to any public activity, is irrelevant to any public interest, or its disclosure would unjustly invade privacy. Additionally, the PIO authority must be persuaded that releasing said information lacks any substantial public interest justification. Activists believe that the intended amendment would considerably dilute the institutional independence of the DPAI while removing Section 81J of the RTI Act 2005. The impact of passage of the Data Protection Bill on the effectiveness of RTI will be felt in more ways than one. Firstly, it will impose limitations on public's ability to access critical information wherever an individual's details form part of the data. This curtailment could put many documents away from the public's eye. Additionally, the amendment is set to constrict access to personal data, potentially affecting the transparency of personal information handling. This may create challenges in obtaining insights into how personal data is managed by various entities. Furthermore, the overall transparency in various sectors and affairs could be influenced by this amendment.
Again, names of willful defaulters of public sector banks, people who take loans, whose bad loans when the public sector banks say of lakhs of crores of rupees are written off, then do people not have the right to know who these people are whose bank loans have been written off by the banks? So all of this information, which is very important for citizens to have to hold the government accountable, will become out of reach of the citizens if this law comes in the form in which the government is getting the bill.
High-profile agreements often require the inclusion of personal details in contracts. If such details were to be scrutinized in public interest, personal details of individuals who are part of the contract would also come out in public domain. But this would be barred by the new Data Protection Bill, compromising transparency in deals involving the government and rich businessmen. Similarly, the Supreme Court has ruled that citizens possess the entitlement to be informed about the identities of deliberate defaulters and specifics regarding the non-performing assets held by public sector banks. But this information could again be deemed private under the new law. Similarly, information about voters list, public distribution system, details of ration cards holders, etc. could be barred under the new bill because they have personal information of general public.
The government is getting a data protection bill into Parliament, which is going to amend the Right to Information Act of 2005. This law, the Right to Information law, has empowered people in the country, across the country, millions of people, to hold their governments accountable. So this data protection law which the government is getting is going to impact the entire information regime in the country. People use the Right to Information law to access information from government on very, very important basic rights. For example, to fight corruption and get their rights like rations, like pensions, a host of other schemes. If a person is not getting their rations, they file Right to Information applications asking for ration records. Only when they find out from the government records how much ration has been given to whom, then they can actually find out where corruption is happening and ensure that they can file complaints and get their rations. Similarly, millions of people have used the Right to Information law to seek granular personal data to fight corruption, to hold the state accountable. Should people not have this kind of information? Also, if you look at voter lists, which basically gives personal information about people, their numbers, their names, their addresses, even their photographs, the voter list is put in the public domain to make sure that there is no electoral fraud, that people can actually monitor that there are no arbitrary deletions or additions to the voter list. Now, if the data protection bill is brought in its current form, there will be a very big question mark on whether people will be able to access this kind of information.
The proposed legislation entails a significant concentration of power among key stakeholders.
Complaints will go to a data protection board, which is a completely government controlled board. Its chairperson and members will be appointed by the government. Similarly, the management of the board will be with the government, and the board will be empowered to impose penalties up to 500 crore rupees. So one can imagine that this will give a very big handle to the government to decide who uses personal data in the country. So the government will decide who cannot be covered under the data protection law and who will be covered. So those people who are raising uncomfortable questions, doing fact findings, doing surveys, opposition parties would all be made data fiduciaries potentially, and this board which will be set up, which will be completely under the control of the central government, will have arbitrary powers to then decide who to go after and file complaints. That is a big fear that people have with this law. So all in all, what the data protection law is likely to do if it passes in the current form is to make the central government even more powerful, empower the government to decide who can hold data and who data information, personal information that they are holding can be controlled under this law, and therefore the people of this country will finally end up getting disempowered.
The government, on the other hand, believes that the Digital Personal Data Protection Bill is a significant step in safeguarding citizens' privacy by fostering a regulatory environment that effectively oversees the processing of digital personal data. The salient provision of the bill requires entities to transparently communicate the rationale behind data collection endeavors as well as the envisaged utilization of the collected data. According to the government, this stipulation augments clarity and accountability in data collection practices. The government says that the main aim of the bill is to make sure that both people's personal information is kept safe and that businesses can use data in the right way. A TOI online report.